All right. Welcome, everyone, to April 4th Board of Adjustment for the City of Canyon City. I now call this meeting to order. Denise, if you're there, could you call roll call, please?
Certainly. Chairman Clark. Board Member Dick.
Present.
Board Member Bonagowski. Board Member Smith.
Here.
Vice Chair, sorry. Board Member Willett.
Here.
All right, with everybody accounted for, and let's do the Pledge of Allegiance, if y'all wouldn't mind, please. I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank y'all. Okay, our last meeting was March 7th. The regular meeting. I would ask for any amendments or for the meeting. If there are none, I would ask for approval of those meetings. Do I have anybody that's making any kind of adjustments?
I move that we approve the minutes of the last meeting.
We have a motion.
Do I have a second?
Yes.
Second.
Denise, would you call roll, please?
Certainly. Board Member Dick.
Present, yes.
Board Member Willett.
Yes.
And Vice Chair Smith.
Yes, here. Next on the agenda is a public hearing. I don't believe we have any agenda items, do we, Patrick?
That is correct. We do not have any public hearing items tonight.
Okay, number 5 is announcements, discussion items, the variance practices in Canyon City as presented by the city planner, Mr. Mulready.
And for the record, Board Member Bonagowski has just arrived to the meeting, so we are all set.
Hello, team.
Everybody.
So I am going to share my screen for my PowerPoint. Sort of a slideshow. So let's go. Okay. So, Mr. Vice Chairman, members of the board, this evening's presentation is in the form of a training exercise about variance practices as they are done in Canyon City. So the first question has to do with the process that we've got. And what I have here is a flow chart that kind of gives you an overview of the land use process in Canyon City. It starts with the zoning phase of this, which occurs either at annexation or anytime after annexation if someone wants to rezone their property in accordance with what the comprehensive plan is recommending as a land use area. You then, after the zoning establishment phase, move into what we call the subdivision and site development stage. And this is where you're actually going to be carving a piece of ground up into usable lots. They'll have access to streets, it will have access to utilities, etc. Now, to the extent that you're going to have a variance, the variance actually occurs when there is a conflict that exists between zoning and the subdivision and site development process. And this conflict has to be to such a degree that strict conformance to the requirements of the zoning on the property or the development standards associated with the use that's being proposed would render the parcel more or less undevelopable. The American Planning Association defines the word variance as a planning term as a request to depart from the literal requirements of the zoning ordinance. This can include relief from setbacks, height limits, parking requirements, landscape requirements, or some other specific performance requirement that under zoning you must comply with once you are establishing the use on the property. Now, the acid test for variance is the existence of a hardship that may exist on the property, and it's important to note hardships cannot be measured in financial terms. If someone's answer for why they don't want to comply with a provision of the code is, well, it's too expensive, that's That's not grounds for variance. That's grounds for them to go back and rethink what they're doing with the property and maybe see if, for example, the cost of parking being prohibitively high means maybe they ought to shrink the size of the building that they're putting in there so that they can afford the park
For proposed construction?
for proposed construction, yes. Now, items that do potentially qualify as hardships would include things like undersized lots, lots with unusual shapes or topography associated with them, lots that have historic resources such as buildings that are on the national or state register of historic places, and lots that have wildlife habitat areas where the wildlife in particular has been deemed as a protected, either endangered or threatened species. The Prebles Meadow jumping mouse comes to mind as one such listed as threatened species in Colorado. And if you go up and down the Front Range, the Prebles Meadow jumping mouse habitat area has caused a lot of consternation in the development community because if you have Prebles Meadow jumping mouse habitat, it is untouchable. You can't do anything with that area of the property. Now, it's important to remember that when you grant a variance, you create something that's called precedent. Anyone else who has the same or very similar circumstances to the situation that's come before the Board of Adjustment requesting a variance, they will get the same variance. So in other words, when you grant a variance, think of it as you've now punched a tiny little hole in the zoning code as to how ironclad the enforcement of the zoning rules are. Punch enough holes and eventually you've made Swiss cheese of the code and anything happens. So you want to be very careful about the precedent and finding that when you are going to grant a variance, the circumstances are unique enough that it's the impact of that precedent is going to be very, very small. Okay, so variance requests, and this has to do with the public hearing aspect of this. They are considered quasi-judicial in nature and are specifically by zoning code left exclusively to the Board of Adjustment to consider. This consideration will happen as part of a public hearing. Under our code, public hearings require a certain type of notice that has to be prepared. And in fact, I have prepared for all of you. This is the actual text out of the code that deals with variances. So there is a table in chapter 1710 that specifies notice. For variances, that requires the notice being published on the city's website. We have a specific page dedicated to public notices. It has to be published there for at least 15 days prior to the Board of Adjustment's public hearing. There also has to be a written notice mailed to all property owners whose parcels are immediately adjacent to the property under consideration for the variance, also at least 15 days prior to the hearing. Now, adequate public notice is what we call jurisdictional to a hearing. If we cannot make a finding that adequate notice has been provided per chapter 1710, then the Board of Adjustment can't conduct the hearing because you don't actually have jurisdiction over the matter. So that's one of the foremost things that I will put into my staff report is, were the notice requirements met? If yes, then we can proceed with the hearing. If not, the hearing is going to have to be continued until notice can be corrected. Okay, so we should have been updating this as I spoke. Next slide. So what are the things that you can and cannot consider at a public hearing with respect to a variance request? Number one, the variance criteria. Again, I would refer you to this little handout here. As specified specifically in 17.10.050B, there are 6 criteria associated with variance requests. My staff report will usually summarize and I will provide my findings on how I have interpreted what these 6 criteria are and how well or poorly an applicant has met these 6 criteria. As always, the Board of Adjustment is free to disregard what I've written and make your own findings if you'd like, but I do include them as a reference point for my Board of Adjustment members. You also have the advice of the regulatory documents that the city has to consider, such as the comprehensive plan, such as our zoning code, such as our subdivision regulations, our site plan development regulations, where based upon the use that's going in, parking requirements are derived, landscape requirements are derived. All of these things come about as a result of the use that's being proposed for parcel. Points raised by members of the public, either for or against the application. You can consider those points up to where you're getting into the emotion of the argument. The facts that come into play are what you have to evaluate. What is this impact going to do to it? If you approve this variance, what is this going to do to the neighbor's property in terms of views, in terms of their enjoyment of their property? These are fair factors to consider. The quality of the proposal and how well or not it answers questions and depicts the applicant's case for hardship. In every application that we get in for any kind of land use, including variances, I always have the applicant include a project narrative. The narrative is where they get their chance to make their argument on paper that this is why I believe I qualify for a variance. These are how I feel I meet these criteria. Sometimes they answer those points, sometimes they don't. But those are fair things to consider. How well did the applicant do when they prepared this application and brought it forward for public hearing? The applicant's proposal in context of the surrounding land uses, lot configurations, and building. So, for example, if you're in a commercial area and someone is proposing they want to have a variance from the parking requirement because they've got some situation that's occurring on their property. Well, okay, do the properties around them that are also commercially zoned, did they have the same condition? Did they have similar conditions? Did they meet their parking requirement? If so, why does this property have a unique condition that those other properties didn't? Do they pass that acid test of there is a hardship that property has that their neighboring properties didn't have? If you can make a finding that the same condition exists on all of the surrounding properties, then that probably isn't a variance request worthy proposal. The impacts of the proposed variance request on the neighborhood itself. What is this going to do to the quiet enjoyment of property, specifically if it's a residential property? What is this going to do to view corridors? What is this going to do to other aspects of the character of the neighborhood? Those are things that is fair to consider in a public hearing. And then finally, whether or not adequate public notice has been given. If that hasn't happened, if you don't have the public notice requirements having been met, then jurisdictionally you can't conduct the hearing anyway. You have to move for a continuance. Now, what's not fair to be considered? The money spent in preparation of the application materials or in advocacy for or against the project. So if you get an applicant who's hired a lawyer who's helped to prepare this and draft the narrative, the fact that they spent billable hours, maybe perhaps ranging at more than $200 an hour, that's not a considerable factor in the variance request. If you've got the neighbors who put together an opposition campaign and they've created a website opposing this, and that website is being charged by a service provider, you can't consider those costs associated with this either. Now, the claims of property owner sovereignty, and this gets into landowners who believe that, hey, I have a right to do with my property what I want. The city can't tell me that I have to do this or I am not allowed to do this. I can do what I want. Well, that flies in the face of zoning. And you should remember that zoning for a century now has been ruled as a valid expression of a community's police power for the promotion and preservation of public health, safety, and welfare. This is a famous Supreme Court decision dating back to the 1920s called City of Euclid, Ohio versus the Ambler Realty Company that established zoning is constitutional. Because of that, yes, if you have a land use within a jurisdiction that's zoned, you have to comply with the zoning. The applicant's time spent in Canyon City prior to submitting the application. You can't find that because the applicant has only been living in Canyon City for 6 months, they're not variance worthy. The variance request has to do with the land, not with the applicant. Personal feelings about the applicant. Again, we're dealing with the land and the variance issue, not the applicant. So whether you like the applicant or don't like the applicant, whether you know them very well or don't know them very well, those are immaterial to the substantive issues of the variance request itself. Quasi judicial matters, personal like or dislike on a project is not relevant. What matters is whether the project can be found to meet the criteria for approval. So again, you might have sympathies that lie with what the applicant is seeking to do. But if what they're doing doesn't meet the hardship acid test for variance, your personal sympathies aren't relevant to the consideration. Now, at the conclusion of a public hearing, the Board of Adjustment is the decision-making body for variances. There is no appeal to City Council. If the Board of Adjustment finds in a way that either the applicant or the neighbors don't like, the only appeal on this is to go through the court system. The Board of Adjustment is the decision-making body. Even council cannot overrule.
It's district court. isn't
It would be district court, yes. The Board of Adjustment has 4 options when it considers how to dispose of a project following the conduct of a public hearing. You can continue the matter to seek additional information, or if there was not sufficient notice given for the hearing. You can approve it, you can approve it with conditions, or you can deny it. Those are the 4 options. Now, you will also be asked to cite findings of fact, and this is extremely important because when it comes to trying to limit the precedence of something, findings of fact are a way to do that. What are the unique conditions that support the variance, or in some cases don't support the variance request? Those findings of fact are, if this is challenged, where the lawsuit is going to hinge. And of course, Austin is online with us today, and he'll have more to talk about this in his presentation. And then ideally, granting variances should be rare and should only be based on the specific hardship conditions that may exist on a particular parcel. Variances are not meant to broadly modify zoning jurisdiction-wide. So if the argument is, for example, hypothetically, I say that word with an asterisk next to it, but if the argument is that fences should be greater than, we should allow fences greater than 6 feet in height. That's not a variance worthy item. That's an item that says, okay, why don't we go back and amend the code, because this is going to affect a broad swath of Canyon City. You can't do this by variance. Effectively, at that point, you will have amended the code without actually amending the code. So that concludes my presentation. As you know, as always, I'm happy to answer any questions that you may have before we go on and hear Austin's presentation.
Okay, yeah, I'd have just a couple things for you. The last thing you had spoken about, I can't remember the word, I'm searching for it. You might as well go back and ask for a change in the code.
Yes.
As opposed to ask for a variance.
Mhm.
How does a person request a change in the code?
So we have, one of the application types is an amendment to Title 17, specifically as it pertains to zoning. And they would have to specify which section, in fact, they want to amend. And then we would evaluate that, staff would evaluate it. We would look at what other communities do. Is this a reasonable request? And then ultimately, if it's amending Title 17, it will have to go to a public hearing before both Planning Commission and Council. Council would have to agree that the proposal is worthwhile, and they would adopt it by ordinance, which requires 2 readings. Planning Commission acts as the filter for this. They will conduct their public hearing and forward a recommendation to Council. So Planning Commission's hearing will always precede the Council's public hearing on this. But yeah, if there is an item that has broad enough impact, and maybe we should consider it, the pathway to do that is to amend the code, not to vary your way into a code amendment.
Well, thank you, Patrick. If there's no other questions, it looks like we're going to go into Board of Adjustment orientation. And with this,
Randy?
Is that true?
Randy, I
Yes.
have a quick question. I'm just curious at this point, and I don't know if it's really pertinent at this stage, whether you can answer it or whether we need some
Mhm.
information from city attorney, but how might the governor's recent announcement about zoning certain portions of the city, it's a statewide blanket mandate type
Yes.
thing that he's issued. have, I would suspect there would be some probably challenges to that, but I'm just curious if it's been addressed or being addressed or.
It is, if council did not adopt a formal position last night at their hearing, I believe they will probably be adopting one on the 17th.
Okay.
So what the governor's proposal amounts to, and Austin, you can clarify if I get some details wrong. What he wants to do is turn the Department of Local Affairs, which heretofore has been sort of a record-keeping agency. When a municipality annexes and changes its boundaries, you have to notify DOLA of the change in boundaries. They have historically also been sort of the mediation arm when you've got disputes between two local government jurisdictions, a city and a county, or two cities that are having a dispute about an area that has the potential to be annexed into one of the particular areas, and whether or not that annexation should happen or not. They also serve as a clearinghouse for federal grants. For instance, when we did our comprehensive plan update and our Title 17 update, or UDC, we had a budget that council had allocated of $150,000, but we also got a grant through DOLA for matching $150,000 that bolstered their resources to double the amount that we could spend on doing this project. So that's historically sort of been DOLA's function. With Governor Polis's proposal, DOLA would essentially be an appeal board for local developers who feel that they should be allowed to have higher density on certain residential parcels. And if they don't get the approval they're seeking through the jurisdiction, they can appeal it through DOLA, who is at this point composed largely of people who are either hired at the state or appointed by the governor. These are not elected officials in the positions that they occupy. And they have the ability under this scheme to overrule local government jurisdictions when it comes to zoning, because they consider multifamily housing an issue of national concern. And there is the potential to have dramatic impacts to the character of existing neighborhoods under this provision. So this isn't necessarily related to variances, because this is sort of taking certain local control decisions and removing them to a state agency that can override local governments. So it doesn't really have anything to do with variances.
Okay.
It's got more to do with things like rezonings and whether or not a rezoning is appropriate or not in a location. Did I cover that sufficiently, Austin?
Yeah, I think I would characterize it as more of like DOLA's an enforcer. Or if the bill passes in the form that it's been put forward, then DOLA would have enforcement authority to institute basically low bars on land use codes. So for instance, if Canyon City, which I don't believe it does right now, doesn't allow ADUs in every single residential district, then a property owner could come forward and say, hey, Canyon City's in violation of the state law mandating that ADUs have to be permitted in every zoning district by right. And DOLA would come in and enforce that on the city and force them to change their zoning code to allow that by right. So it's a very similar scheme to how Patrick described it, but it's essentially that this bill would be creating a lot of low bars for land use regulations. And if a municipality doesn't meet them, then DOLA will enforce that they do.
But again, one of the complaints that local governments all over the state and the Colorado Municipal League have been making is this is sort of abrogating the relationship between the state government and local governments when it comes to local decision making. That's a big piece of why a lot of local governments are very upset about this.
And it's definitely not clear how all pieces are going to apply, particularly if you're a home rule municipality. And so there's, I think, some or quite a few questions yet to be answered. And we'll see how that plays out. But I think they did announce what group Canyon City would be in. And I think they put them in like the third group or something, which has some of the least restrictive requirements. But it's just a bill right now. So we'll see if it becomes law.
Oh, okay. Just curious, answered my question.
Okay.
Anyway.
So
We could
Austin,
probably talk about that all day.
I have your PowerPoint up. If you want to tell me when to change, I will be happy to change slides for you.
So do you mind if I share instead? I changed a couple slides last minute. If not, it's okay.
That's perfectly fine.
Okay, excellent.
All
Thank you.
yours.
Appreciate it. Okay. All right, are you guys seeing what I'm seeing?
Huh?
Excellent. Okay, well, I'm happy to be here. So my name is Austin. I work with Corey and Catherine as a part of the city attorney's office, and I particularly work on planning and land use stuff. So I work with Patrick a whole lot.
And
So
he's
today
a great resource.
Today we're going to go over quite a few things. So this is the agenda for today, and I'll take a break halfway through and see if there's any questions. But if there's anything that kind of stands out while I'm talking, feel free to cut me off and we can just stop at that point as well. And I'll go through these pretty quickly. I want to leave plenty of time for questions and do it pretty much at a high level. And if you guys want to get into more of a weeds, I'm happy to do that as well. So just to start, and I think Patrick did an excellent job of covering this in his presentation, but the Board of Adjustment is a quasi-judicial body. And the duties of the BOA are enumerated in section 250.020 of the municipal code. And as Patrick mentioned, the principal duties are in relation to variances. There's also some other carve-outs there that the city can use if it chooses to. For instance, other appeals could go to the BOA, and then the city council obviously has discretion to enlarge that power or shrink it. And interesting enough, this is pretty uncommon with these delegations of powers. There are explicit carve-outs of what is not in the BOA's authority in the code. So I just wanted to quickly list them here. And that's to permit land uses or review any action or determination by the city council. So not really necessary to say that. All you have to say is the part above is what is your authority, and everything else would be outside of it. But I thought it was interesting enough to highlight it here that the code thought that was an important thing. So some general legal considerations as a BOA member. When you're acting in, should always act within that scope of authority that Patrick mentioned, and that was on the previous slide. When you're doing so, you're acting as a body, not as individuals. So no single member has the authority to act on behalf of the city their own. BOA has to act by a majority vote of all members present, and that must be a quorum in any case. So it's got no authority to spend city funds, no authority to direct or supervise city staff, and that includes Patrick. So you can't tell Patrick, hey, Patrick, we want you to research X item and bring us back a report. You can definitely mention that. So, it'd be really interesting if the city took on this report. Patrick, could you mention it, to Ryan? Ryan should really make the determination. The city manager should really make the determination of how city staff spends their time. So a quick thing to point out, because I get that question a whole lot. So any legal advice I provide as well, or Catherine or Corey provide, is always confidential. That's the general rule. And the body that has the authority to waive that privilege is city council. So city council is the only one, even though the privilege might be between BOA and myself, city council is the only one that gets to waive that privilege. And then just some other quick things. There's no authority to bind the city legally, so you can't go entering into contracts as a BOA member on behalf of the city. And of course, goes along with the first point that the BOA is not a separate legal entity apart from the city. Okay, so just taking a minute, zooming out a little bit about what are those typical functions of a governing body, and taking a moment to distinguish them and then placing the BOA and within their scope of authority. So as mentioned, the BOA has quasi-judicial authority. So that means that they have the authority over those discrete actions related to a single item. So like approving or not approving a variance. So when you're doing any quasi-judicial action, there's due process considerations that are triggered. And Patrick mentioned this. There's really three main things when you think about due process. It's notice, a public hearing, and the right to a neutral decision maker. If you lose any one of those, then you lose, or you just took away someone's due process rights founded in their state and federal constitution. So you want to be really careful about those concerns, about the notice, the fact that you're making decisions only at a public hearing, not saying before to an applicant, don't worry, I'll get this approved for you, and that you're neutral when you come to the hearing to make the decision. And again,
Hey, Austin.
yes, sir.
Can you explain a little bit about what neutral decision maker means?
Yeah, absolutely. And so I think this is really getting at one of the later bullet points of you shouldn't have bias coming into it. So for instance, if you represent a fence company and you make more money the bigger the fence is, and you want to really drive home that prerogative that I want bigger fences here, so you decide to approve every fence permit that is an additional height because it benefits you. That's not a neutral decision maker. You're not acting without bias. You've already decided the application before you even see it, and you're certainly not applying the criteria in the code to that specific application. So we've got to be sure that when you're making a decision, you're doing so just based off of the criteria in the code and doing your best to leave your personal judgments at the door. So as much as you might love or hate a certain kind of development or a certain kind of area in the city or want it to be something different, you kind of have to leave those judgments at the door to afford the applicant that neutral right to a decision maker. Does that make sense, kind of, more or less? Okay, cool. Okay, and so the other things we kind of touched on as well. So being fair and impartial, not engaging in ex parte communications. That's again the example of talking to the applicant beforehand, coaching them on their application, teaching them about ways to get it passed or whatever it might be. So you certainly don't want to engage in any of those things. And all quasi-judicial actions are subject to judicial review, again, as Patrick mentioned. So then you can compare that to some other functions of government, like legislative functions that city council has. This would be like adopting a zoning code. It's a legislative action. It's broadly applicable. It's not a discrete application. There's a whole different level of legal standards for those actions. And then compare that to a more administrative type role. And I think this is the hat that's hardest to come off, because people, if the community knows, and they do know, that you are Board of Adjustment members and you represent the city, it's really tough to take that hat off. So what I recommend is go about your personal life, but try to refrain from saying things like, well, as a Board of Adjustment member, I think X. Or going to a city council hearing and say, well, I know the Board of Adjustment, I'm a member, they're not going to like this, sort of a thing. So just trying to separate those hats as best as possible. That certainly doesn't mean that you can't engage in those conversations, go to city council and give your input on matters, but it's important to do so in your individual capacity and not in the capacity of the Board of Adjustment as a whole. Okay, so that was a lot, actually. Any questions on all of what I just covered before we move on and talk about CORA? Okay, excellent. So let's talk about open records. So this is governed by the Colorado Open Records Act, which is colloquially called CORA. And under CORA, all public records must be open to public inspection. This is the public records is defined extremely broadly in CORA to include all writings made or maintained or kept by a public body. Case law has interpreted this as text messages sent during a meeting. So if you guys are texting each other during a meeting, that can be subject to CORA. Those can be released as a part of a CORA request. It also can include any type of email from your professional account or any email on your personal account about a professional matter.
Which is why, this is why we set up the @canyoncity.org email survey, so that your personal emails would not be subject to a search.
Yeah, you certainly don't want that. And there's very limited exceptions in CORA. And what I mean by that is when we get a CORA request for certain information, say on an application that the Board of Adjustment has handled, the CORA request will say, we want every single document related to this application or stating this string of words. We have to go through every single document and get those together. The legal team will then redact what we can, but our authority to redact is extremely, extremely limited. So all this to say is, just be careful when you're sending messages from your Canyon City email address, or when you're in a meeting, try not to engage in text messages with other commissioners or what have you. Because even if they're completely unrelated to the matter at hand, they can still be subject to public disclosure. So now onto open meetings. So this is governed by the Colorado Open Meetings Law. It's typically referred to as the Sunshine Law. this is essentially just a notice requirement is what the Sunshine Law is doing. It's saying that when you're having a public meeting, you have to give 24-hour notice of what's going to happen at that meeting to sufficiently inform the public of their ability to comment on that matter and to give their 2 cents. So yeah, that's the important part. The other pieces that come into this probably won't affect the Board of Adjustment too much, but if there ever is sort of those last minute changes to the agenda, hopefully it's 24 hours out, but if it's within 24 hours, then I typically advise that you do a couple things on the record to just get ahead of this issue. So if that ever comes up, we can discuss that issue as needed. And then the other point to mention is, again, that case law has determined that emails can constitute a meeting under the Sunshine Law. So if you're ever receiving emails from Patrick and all of you are copied on them, it's really important that you don't reply all back to everyone, because if you did, then you just had a meeting and it probably wasn't noticed. And so we probably just violated the Sunshine Law. And people do it inadvertently, but it's become more and more of an issue with these broad cases capturing these statutes. So just be careful not to include more than one other Board of Adjustment member on any email you sent, or it's technically considered a meeting and needs to be noticed. So I very much doubt that you will run into executive sessions much as a Board of Adjustment, but just really quickly, it is an exception to the Sunshine Law, and it basically gives an exemption to that general rule that all meetings must be open to the public. But because it's a carve out to that general rule, it's a super, super particular, and you have to go through a lot of legal steps to get there. So if you ever feel that an executive session should be added to the agenda, just let Patrick and I know beforehand, and we'll give the chair a script to read from to ensure that all of those legal boxes are checked. Okay, conflicts of interest. So there is a whole heap of law governing conflicts of interest in Colorado, but they can pretty much all be boiled down to: do not, as an elected or appointed official, make a decision that benefits you economically. So what that means is if you are a proprietor in a business that has a variance coming forward and you will financially benefit, or your company will financially benefit if the variance is granted, that's probably a conflict of interest. And in those cases, I would ask that you follow these steps. So first, you disclose the interest on the record. You'd say on the record, hey, I just want to let you know that I might have a conflict here. I'm a proprietary in this business. I would stand to benefit financially if this application was approved. Once that's on the record, you typically have some discussion amongst the Board of Adjustment to let them say, like, yes, I agree, or no, I don't. If it comes to the decision that there's a majority that this is a conflict of interest, then you should recuse yourself and leave the room and not try to influence the decision at all. And one important part to note that also comes up a lot is that there's very few reasons you can actually abstain. So your job is to vote on every matter in front of you, and you may only recuse yourself if you have a conflict of interest. So it's not appropriate to recuse or abstain from voting for some other reasons. I get it a lot for folks that want to abstain from a political vote that has a lot of political contention. You can't do that. You have to vote on those issues. Even if you're not 100% sure you want to vote yes or no, you still have to make a decision and vote yes or no on any matter that's on the floor. Okay, I think this is the last one. So just really quickly, as a appointed and elected member, or appointed or elected member, you do come under the Governmental Immunity and Personal Liability Act. That essentially means that if you're acting within that scope of authority that we talked about on that first slide, then you have some immunity from a tort action. So if someone's trying to sue you saying, hey, you didn't approve my variance, you voted no on this, I'm going to sue you personally, this hurt my economic interest, you would be immune from that suit. So we could get you dropped from that suit very quickly. I think that's all I wanted to say. And I know that was a whole lot in a fairly short period of time, but I will stop sharing and see if there's any questions.
Good. I don't think we'd ever qualify for a executive meeting.
I don't believe the Board of Adjustment ever has. I don't think Planning Commission, at least in the 5 years I've been here, has called for an executive session. Council does it fairly frequently because sometimes there's a contract or something that comes before them. And they need to get some legal advice from the city attorney before they consider that matter on the record. And it's not that we wouldn't provide Board of Adjustment or Planning Commission with an executive session if the reason came up. But if there is gonna be one, we would, I mean, if you think it's necessary that before we hold the meeting, we have an executive session, let me know so that I can let us know. We can find out what the rationale and the script is
Yeah.
to stay on the record to declare an executive session, then we can go into the ante-chambers room for meeting. I mean, I don't know off the top of my head what such a circumstance might look like, but we're certainly willing to engage that if it becomes necessary.
It's valid for personnel matters and negotiations that are in the public, or advice from council. I think that's the only two reasons why you can have an executive session.
Yeah, there's about 5 listed in the statute, but those are certainly the most common. It's for the purposes of negotiation or receiving confidential legal advice. So for instance, if someone's really grilling you guys, an applicant's really grilling you and saying you're applying your criteria wrong, you did it this way before, instead of having that conversation publicly and saying, yeah, you know, you're right, we applied it that way before, we want to change our mind now, it'd probably be best in those cases to say, hey, we'd really like council's input on how to navigate this issue. Can we call an executive session?
So is presumably every time we meet, it's a matter of public record?
Yes.
Is there ever a time that when we don't have a case in front of us, but maybe we wanted to meet for some unrelated reason, just for like the solidarity of our team, or a matter of this, like order and procedure,
So-
that would not be on the record? Is there ever a
So
reason for that?
I think the answer to that, Austin, correct me if I'm wrong, is that if the Board of Adjustment members, or for that matter, the Planning Commission members, wanted to get together, maybe to have like a celebratory dinner because someone's birthday has come up or something like that, you could probably do that, but we have to at least post the notice.
Yeah.
So that the public knows that there's going to be a gathering of, you know, the Board of Adjustment or the Planning Commission who act in this capacity on behalf of the city. There will be no, you know, there will be no formal business conducted, but there is a meeting going on so that we meet the intent of the sunshine laws.
Yeah, that's exactly right, Patrick. So you get this a lot for APA conferences. So we almost always just notice right off the bat, like Board of Adjustment and Planning Commission meeting or members plan to attend every single American Planning Association conference, just so we don't miss it. And if someone wants to talk to you from the public at that time, then they have that right too.
So if we get a new board member who doesn't know all of our procedures, the learning will be public.
Oh, yes, oh, yes.
Okay.
Yeah, we'll give a variation of this same presentation to whoever the new board members are. And right now, we do have 2 vacancies for alternate positions. So if you know anyone who might be interested, please, you know, inform them about the open position, have them get a letter of interest over to our city clerk so that they can be considered by council and potentially appointed to the board.
And this is a good faith. It's a volunteer position, so make sure you don't tell them they're gonna get paid lots and lots of money.
Well, you guys got a 100% increase in salary this year.
Yeah. Every year.
It's not in my paycheck.
Well, this has been really helpful for me. So thank you, Austin. Thank you, Patrick.
Sure.
Appreciate it.
Thank you very much. I won't be here after December. I turned 88 and I think it's probably the end of my public service. And so I enjoyed feeling like I was part of a community that cares, has a future. And yet I think it's time for me to get out of the way and let somebody else.
Okay, well, again, if you know someone who might be interested in taking your place come the beginning of 2024. Please inform them. If they've got any questions, they can call me and I'll be happy to talk to them.
And thank you for your service, Dan.
Well, my pleasure. The greatest honor I ever had is to be elected by the people to serve them.
Okay, gentlemen, are there any other issues we need to discuss that are possibly not on the agenda? Anybody wants to get out there?
Don't believe so. I got what I came for.
In all likelihood, we will not be having a May Board of Adjustment meeting because at this point I don't have any items in the pipeline. But I will give you formal confirmation of that towards the end of April.
All right, and that's what I was gonna just say, that the next scheduled meeting is Tuesday, May 2nd, but if we don't have any items, then we will meet in June or July or August. So if there are no other issues, I would like to go ahead and adjourn this meeting for today. Okay,
That would be fine.
Okay.
Thank
Okay.
you.
thank y'all very much for meeting, and we'll see y'all next time.
Okay.
Thanks so much.
Appreciate it.